Hello and welcome everyone to our webinar presentation today. What is the October Visa Bulletin really telling us? My name is Ron Hoppe. I'm the CEO of Worldwide Health Staff Solutions, and it's my pleasure to be guiding our presentation today. I'm joined by my colleague, Dwight Myfelt. Dwight is a leading healthcare immigration attorney here in the U.S., and Dwight has been kind enough to join us today to help us explore what the October Visa Bulletin is telling us. If we can get to the next slide, please. So as we contemplate what it is that we're going to be covering today, I think as most of you may be aware, the October Visa Bulletin each year is a significant event. Something that we watch for very closely because October 1st also represents the beginning of the U.S. government's fiscal year, which brings with it a new annual allotment of EB3 visas. So that's the focus, why we have this strong focus on the October Visa Bulletin. And we're going to dive into that here in just a moment. But before we do that, I'd like to acknowledge that just over the past couple of days, over this past weekend, that there's been some fairly significant announcements and some fairly significant developments related to U.S. immigration, specifically in the H-1B visa category. The H-1B visa category is used by, in some registered nurse cases. It's also used in medical lab technologists and some other allied health professionals. These developments will not be the focus of our presentation today, although we will speak to them at the end or towards the end of our presentation regarding the Visa Bulletin today. So if you have questions, whether your questions are related to the Visa Bulletin or whether your questions are related to the developments here of the past 2 or 3 days, please use the chat section of your screen to send us your questions. One of our colleagues is standing by to monitor those questions, and we will do our very best to save time to be able to respond to those for you. Lastly, before we jump in, we always ask for those of you that are joining us live to just take a moment and again, using the chat section on your screen, just drop us a quick note letting us know what country you're joining us from. We always like to know, how far these presentations are reaching, even for the live presentation. So if you'd be kind enough to do that, that would be greatly appreciated. All right. So with that being said, if we can go to the next slide, please. So before we get into the actual Visa Bulletin, let me again just take a moment and welcome Dwight. Dwight, thanks for being with us today and for helping us walk through and understand the October 2025 Visa Bulletin.
Thank you, Ron. It's a pleasure to be here.
All right. So what we have up here on the screen right now is a snapshot of the October 2025 Visa Bulletin. Specifically in the EB3 visa category. So Dwight, if you would just take a minute and just kind of walk us through what this chart is telling us right now.
So the first thing I would say is that so each year 140,000 green card immigrant visas are allocated for employment-based cases. And what happens is that the government has categorized those by the nature of the occupation, the educational experience requirements that are required to do the job. And when you're talking about registered nurses, they fall into the third employment-based category. So because there is a backlog that built up, meaning more people apply each year than there are visas available, the government has created waiting lists, and you get in line on the waiting list on the day that your case is filed with USCIS, specifically with regard to nurses. And then what happens is each month the government releases the visa bulletin, and that says how far along the waiting line is used. It has moved. So what you would do is you would look at your priority date, which is the date you've been given to get in line, and then you would look at the visa bulletin. On the visa bulletin, you would see what the current cutoff date is. And if your priority date is earlier or older than the current cutoff date, then you're allowed to file your case to move to the second part of processing. The first part of processing is what the employer does when they file the immigrant visa petition. The second part of processing is what the employee does when they want to claim that visa. So if you look at the October Visa Bulletin, there's one category. It's called all chargeability. We sometimes call it the rest of the world. And for EB3 in October, that says that anyone that has a case that has a priority date earlier than April 1st of 2023 is now allowed to move to the second part of processing, which is if they're outside the US, that means they're now eligible to have their visa processed at a US consulate. If you look at the Philippines, which is also a country where many registered nurses come from, the cutoff date is the same. It's the 1st of April of 2023. So if your priority date is older than that, you're now eligible to move on to the next part of the final part of the processing, which is getting your actual immigrant visa petition approved and being given permission to travel to the US.
And we can see for India and China, those dates go back much, much further, right? Yeah. India, the cutoff date is August 2013. That is not a typo. That is actually correct. And for China, it goes back to March 1st of 2020. Also not a typo. Dwight, could you speak just briefly to the other workers category within EB3? What is it? And why are the priority dates for other workers different than they are for the skilled workers within EB3?
So the categories on the Visa Bulletin are essentially, when you're talking about the first several, they're ranked in terms of the level of skill that is required to do the job. So, for example, when you talk about EB1, you're talking about very accomplished people who have outstanding sets of skills, or they're high-level executives, they're high-level managers. EB2 is a category that's reserved for people who are coming to take a job that requires at least a master's degree or a bachelor's degree and 5 years of experience to do that job. EB3 is for professional. Part of it is for professionals that don't require a master's degree, but you also have other workers are just basically that's a lower level of skill. And because we prioritize because the government prioritizes the Visa Bulletin in terms of the level of skill, that would be the lowest level in those first four categories. Therefore, they have the least priority, and that means that they are going to have a little bit longer to wait for their cases to be processed.
Right. And we can see here that where, for example, the priority date for registered nurses, April 1, 2023, when we look at the other workers category, where we would have, for example, candidates with nurse aide type of job offers, where the priority date for them is backed up almost an additional 2 years. So currently July 2021. If we can go to the next slide, please. So Dwight, as we were waiting for the October Visa Bulletin, we were hopeful for forward movement. Really, the Visa Bulletin kind of stayed static. And we have a chart showing that here. We'll put that up in just a moment. But as we received the October Visa Bulletin, there was really no forward movement, where in previous years, 23 and 24, when the October Visa Bulletin rolled around, or at least the November Visa Bulletin, we did see some forward movement. So interested in your thoughts on, what does it mean that come the October Visa Bulletin, we really didn't see any forward movement from, say, the September Visa Bulletin? And if we could, while Dwight's commenting on that, if we could just pull up the next slide with the chart on processing times.
So essentially what historically we have seen is through, because again, the beginning of the government's calendar year is October 1st. And because they cannot give out more than 140,000 of the green cards a year, what we tend to see is that in the late months of the summer, processing slows down or gets cut off altogether as they get close to that point in time where they think that they're going to run out of the immigrant visas. So when historically what we've seen is that when we get to October 1st, there's a reset, and then suddenly a new year's worth of visas become available. And often we've seen some fairly significant jumps forward. We were then surprised when we got to when we received the visa bulletin for October this year, and we did not see the kind of movement that we would have anticipated. And unfortunately, the government never communicates, at least not in a way that we're ever satisfied with, to us the reasons for why there's significant forward movement or there's not significant forward movement. And there could be a variety of explanations. It might just be that they had opened the floodgates a little too wide earlier in the summer or late spring, and now they still have to process through those visas. And so it's going to take them to get through October before they finally get through everything. We have seen that on a couple of occasions, that we've been a little bit disappointed in the October Visa Bulletin, but then there's been a surge in November. And I think probably the answer is they had enough cases that they had accumulated during the latter part of the prior year that when they got to October, they said, yeah, we still have to keep the number. We have to keep the visa bulletin fairly static while we process those, and then we'll move it forward again in November. I'm not saying that's what happened this year, but that is certainly a possibility. But we don't really know the answer as to why we did not see the kind of movement that we were anticipating this year.
Yeah, I know that everybody's now closely watching for the November visa bulletin and hoping that perhaps we'll see some forward movement there. Fingers crossed for that. If we can go, so just before we go to the next slide, I'll just briefly comment here. So if you look to the right side, the right portion of the chart, you can see that there's lines that indicate 1 year or 2 years. So that's 12 months, 24 months of processing time. So when you consider that the priority date is April 23, and we're now well into September of 2025, that we're sitting essentially at 29 or 30 months of processing times. If this was to hold steady, that is, if the visa bulletin was to move forward 1 month for each calendar month, a new petition filed today, you would expect a visa to be issued 29 or 30 months from now. So we can go to the next slide, please. So, Dwight, maybe if you could take a moment, and I know we've done presentations on this in the past, the visa bulletin, the difference between final action date and the filing date, and your thoughts on the currently stated filing date. And do we think that that date in any way predicts the future of the final action date?
So the dates for filing date. So the final action date is the kind of hardline date that an officer is not allowed to issue a green card to an individual if their priority date is not current on that date. But because many, many people were in the United States on temporary work visas, the government a few years ago decided they were going to implement something called the dates for filing chart. What the dates for filing chart says was that if you're in the US, this doesn't affect cases processed directly at the consulate, but if you were in the US and USCIS decided that they were going to agree to accept that chart for that particular month's cases, then they would, if you had a date that was behind the dates for filing chart, you would be allowed to file your case. And then your employer wouldn't have to continually file renewals of your temporary work visa. You could just use the employment card that came with your application to adjust status. And that's not always accepted by USCIS every month. They have a right to decide what whether or not they're going to accept it for that month's set of cases. But we view that as a predictor, because basically what the government does is they've kind of said, okay, this is how far we think the visa bulletin is going to move in the coming year. So we're going to allow people that we think we would eventually get processed in the coming year to file. So you'll see that that date is typically a little bit better than, well, sometimes significantly better than the current visa bulletin, but it's essentially set in October, and then it doesn't really change very often throughout the year. So it's best used as a predictor of how far the visa bulletin is going to move. And this year, it does not seem to be very optimistic, because it only has them moving out, a few more months than where we are right now. So that also is not necessarily the most hopeful indicator of how things might go, but that is essentially, and it's by no means a guarantee, the visa bulletin, if cases move quickly and for some reason a lot of cases aren't filed in response to visa bulletins, they can move the visa bulletin beyond that date, but it's just kind of a predictor of where the government thinks cases might move in the coming year.
Yeah. I think that's a very important point for our guests to be aware of. And we've listed here kind of what this relationship between the final action date and the date for filing was back in 23 and 24. So you can see as we got to October 2023, the final action date at that time was December 1, 2021. And the date for filing was January 1st, 2023. And you can see the same data for 2024. What's interesting is that the date for filing that was communicated in October of these respective years was very accurate. It was within a month of what actually happened over the course of the year. And given that in the October 2025, that's a typo on the right, that should be October 2025 visa bulletin, that it indicates the date for filing is only going to move to July 1, 2023. If in fact that is the case, that would be very concerning, because it would seem to indicate that over the next 12 months, the visa priority dates are only going to move forward by 3 months. So again, something that we'll be watching very, very closely in terms of what overall processing times may be. If we can go to the next slide, please. So, Dwight, given the fact that we've got these visa backlogs, processing times seem to be taking longer. They certainly have been taking longer over the course of 2025. I know that there's a number of initiatives or proposals underway in terms of policy and potential immigration reform. Just interested in your thoughts on what, if anything, that you think could change here over the course of the next year, notwithstanding the news of the last couple of days.
So the interesting thing to me has always been the fact that no one denies the fact that in the United States we have a desperate need for healthcare workers.
Correct.
The unfortunate thing is that we have never, for some reason, despite numerous proposals, been able to implement a new visa or an expansion of the number of visas that are available for healthcare workers to resolve that problem. And if you take, for example, the Healthcare Workforce Resilience Act, the proposal there is not to create a new set of visas, but what happens is the government gets to the end of each year and they have a certain number of visas that just don't get issued for whatever reason out of the 140,000. And they're not used. And right now there's no provision that allows us to go back and recapture those unused visas. So this act isn't even asking for new visas. This act is just saying, hey, why don't you let us go back and recapture the ones that never got used for whatever reason that were statutorily authorized, and let us use those for healthcare workers. Now, to me, it seems like a fabulous plan, and I don't understand why anyone would have any objection to it. It's been proposed by a couple of fairly prominent senators, and you would hope that that would provide us some relief. If in fact it were implemented, it authorizes the recapture of up to 25,000 green cards for nurses, and I think the number's 15,000 for doctors. So an extra 25,000 visas for nurses would be a fabulous development that would really let many, many people who are in the system right now waiting for forward movement in the visa bulletin to finally have their cases processed and come to the US so that they could join the healthcare workforce. If you wanted me to speculate on whether or not that was going to be successful, I would say to you, it just is absolutely impossible. It seems reasonable. It seems smart. It's something definitely that we absolutely need. So I would say, why in the world would that not be implemented? But to this point in time, there have been several great proposals that haven't been. And so it's really hard to say what the possible success of that might be.
Right. Okay. Fair enough. Dwight, can you maybe just expand just a bit on, let's say, the Healthcare Workforce Resilience Act as it's currently proposed, recapturing 25,000 visas, particularly or specifically rather for nurses. Obviously, 25,000 more visas is a good thing, but what would be the, if that was to pass, what would be the immediate implications of that in terms of applicants and process? The number, right now we're counting family members against visas, etc. How many more nurses do you think would actually be able to come into the country, and what could that timeline look like?
Well, that's a great question. I don't really know the answer, but if you made me speculate, what would happen is that many of those cases are they've been mothballed by the government while they wait for the visa date, the priority date to become current. So I imagine that it would take several months for the government to go through and actually identify cases that would be eligible to be processed under this act once it was implemented. Then they would have to notify the MVC to start moving forward on taking action on those cases, which would probably take 30 to 60 days for them to do. And then the interviews would have to be scheduled at the consulates. And the interesting thing is the consulates are already kind of at full capacity. So it wouldn't be suddenly like they could open the doors and say, all right, we've got 25,000 interview slots. So what I imagine was it would take a couple of months for the government to identify what candidates would be eligible to be processed. It would take a couple of months for the MVC to process those cases and move them on to they have to they don't send the files to the consulate till the case is ready to be interviewed, because the consulates obviously would have no place to store them. So they've got to finalize those and then send them on to the consulates to be scheduled for an interview. And then you've got the consulates to have to start working those in. So I would think, honestly, that even if it became effective today, you're probably looking at people not getting interviews at the soonest for 3 or 4 months. And then from there, it's just how quickly can they slot them in. So it might be anywhere from 4 to 8 to 12 months before that first. Now, in the second year, it's going to be a little different because they know what the plan is. But in the first year, I'd say probably 4 to 12 months before they would work their way through all of those interviews.
Okay, very good. We can go to the next slide, please. So we've spent some time talking about the October Visa Bulletin, what it's telling us, what projections we can possibly make for how far the progress in the priority dates will be between now and September 30th. An indication, not an exact confirmation. So want to just take a moment and talk about taking control of the process. What can you as an applicant do to feel that you have some control over a process that at sometimes you can feel is completely beyond your control? And I just want to encourage you today that it's not. So I say this often, and I'll say it again today in this presentation because it's true. If you have a currently pending EB3 application that was properly filed on behalf of a bona fide employer, your question is not, will I arrive in the United States? Your proper question is when, right? It's a question of how long is this going to take? It's not a question of if, right? Under the current rules, which have been in place for pretty much 30 years or just over 30 years, right? If you have a properly filed petition with a bona fide employer, you would have a very, very high expectation that your visa will be issued. So I just want to make sure that that point is clearly understood. But in terms of feeling that you have some sense of control over the process, I would share just a couple of thoughts with you. And that is, first of all, understand what your next step in the process is, right? You may not be able to ultimately speed up the final disposition of your application, but you can certainly slow it down, right? And what I mean by that is, your application moves forward in several stages, and it's always important that you are prepared for the next stage so that when you're able to move to that next stage, that can be accomplished expeditiously and without any further delays beyond those already being caused by processing times. So an example of understanding the next step in your process would be prioritizing, right, and completing your visa screen certificate and other related requirements. So if you go to our YouTube channel at Worldwide Health Staff Solutions, you'll find separate presentations there just on the visa screen process, but making sure that you are aware of what the next step in your process is and being prepared for that at the right time. Super important that you're not adding further to the delays that are already taking place. So I think that's an important point. And then just from a personal and motivational perspective, it's very easy to focus on what hasn't happened or what hasn't been done. I would just encourage you that if you have a pending application, right, to focus on the progress that has been made, right? Maybe your petition has already been approved. Maybe your application is already documentarily qualified. Or maybe you're more at the front end of the process and your petition has been filed, but you're waiting for an approval date. I think regardless of the stage that you're at, just the fact that you have been able to have a permanent residency application filed on your behalf is a significant accomplishment in and of itself. So as we continue to monitor the processing times, obviously super important. But remember, the question is when, not if, and to be focused on what the next step in the process is and to be very well prepared to take that step if and when you have the opportunity of doing so. Any other thoughts, Dwight, that you might add just in terms of encouraging our guests, in relation to having some control over how this process plays out for them?
Yeah, I think a couple of things that I would add are that if you've been waiting for a fairly significant period of time, there may be some things in your life that have changed, whether it's your contact information, the address where you're living, that you need to make sure that you stay in contact with your sponsor so that they can contact you. They know how to reach you immediately. If in fact something happens and your date, it's suddenly time to move on to that final step and prep for your interview. The other thing I would add, a lot of people don't realize, is that if you've had children since the time that your petition was filed, there may not be a case that's been created with the MVC for them. Or if you get married, there may not be a case that's been created. You want to notify your sponsor so that they can start putting into place actions that need to be taken with additional family members so that everything is in line for them as well. You don't want to be in a mad scramble or delaying the preparation to go to your interview when it turns out you have family members that have not been referenced at all in your application. That can become a little complicated. Make sure that your state licensure in the US is as complete as it possibly can be. And the other thing I would say is don't forget the visa screens do expire and it takes some time to renew them. So if you've had your visa screen for 4 or 5 years, you want to make sure that you have completely processed the renewal so you have that in hand should you get a notice that says, hey, your interview is ready. It's time to go.
Okay, thanks, Dwight. Thanks for sharing those additional points. If we could go to the next slide, please.
Looks like Ron dropped for a second. Let me see if we can get him back on.
Just some technical difficulties here. Sorry, I got kicked off. So just to follow up on the comments about taking control of the process, for those of you that are in process or have been in process for some time, just a couple of further thoughts to share with you by way of encouragement. The first in is to understand this concept of first in, first out. That's why your priority date matters and it's important. All things being equal, visa applications are processed in the order in which they are received, right? So a petition that's received and entered into the USCIS system on a Monday, for example, in theory, is going to have a visa issued before a similar petition that's filed next Friday. So, whatever the backlog may be, you focus on your priority date. That's super important. With regards to priority date, there is one other point I'd like to make that's really super important, and that is for applicants who have had petitions filed and they've been filed some time ago and you still have not received an approval notice. Okay. The fact of the matter is, USCIS adjudication times, initial adjudication times, have also gotten longer. So it is possible that you will have had your petition filed and hanging out there maybe for 6 months, maybe even 12 months or longer, even now, right? Without an approval notice being received. I just want to be very clear and remind everyone that your priority date is established based on the date on which your application is first entered into the USCIS system. It is not based on the date on which your application is approved. So in theory, let's say it takes 12 months for your petition to be approved. In theory, you would have a priority date that would be somewhere around 12 months prior to that time. So first in, first out, that's important for existing candidates. For those of you that may just be considering getting started on your immigration journey, and we hear from many of you, and a very common question is this the right time, right, for me to pursue my American dream? Is this the right time for me to start on my immigration journey? And the answer to that question in my mind is the best time is now, right? The visa bulletin isn't where we want it to be necessarily, right? There's some other uncertainties around just how the visa process is going to look going forward. But the fastest way of getting through the existing process is to have a petition filed on your behalf. Okay? You cannot file a petition yourself. You must have a sponsoring employer. But regardless of what the processing times are, whether they're 12 months, 18, 24 months, something else, your fastest way of getting to the US is to get in line. Have a petition filed, establish a priority date, and then proactively, ensure that you're ready to move through the process expeditiously. Right. So first in, first out. The sooner you start, the sooner you're going to get to the finish line. Right. The journey may take time. but each step moves you closer to your ultimate goal. So be focused on the next step, not necessarily on the last step. Uh, Now, I don't want to be dismissive of the need for planning and future planning. There needs to be some of that for certain. But in terms of focus, unless the next step is completed, the step after that really is irrelevant, right? And today's patience, the patience that you exercise today, is going to allow the opportunities that you're hoping to find to become reality tomorrow. So, just a couple of thoughts by way of encouragement. Both Dwight and I have been working in the healthcare immigration space for many years. We've seen processing times be shorter. We've certainly seen processing times be longer. And through it all, right, where the candidates and employers have stuck with the process, the process was successfully completed. All right. So, with that being said, I do want to move on. If we can go to the next slide, we do want to speak about H-1B visas. There's a lot of questions that we receive regarding H-1B visas for registered nurses, as well as H-1B visas for other healthcare professionals. So, Dwight, if you could maybe just talk about the pros and cons of H-1Bs for registered nurses prior to the news of this last Friday, which we'll get to here shortly. But if we were doing this presentation, last week on Thursday, what would you have told people about the pros and cons of H-1B visas for RNs?
So, just a quick overview of the H-1B visa itself. I always tell people that there are three basic requirements that have to be met in order to be eligible for an H-1B visa. The job that you're coming to take has to require a bachelor's degree. In the US, there is no state right now that requires an individual to have a bachelor's degree in order to get registered or to get licensed as a registered nurse. So entry-level nursing positions do not qualify for an H-1B visa. However, if you're talking about acute care or critical care areas, those most definitely, you can make a compelling argument that an individual needs a bachelor's degree or the equivalent of a bachelor's degree based on the combination of work and academic experience. And there are many H-1B visas that are issued for registered nurses working in areas like ICU and PICU and NICU. And OR and ER, because those require nurses with a higher set of skills and work experience. So that is absolutely a possibility. The one problem that the H-1B visa poses is that for employers who are not nonprofits that meet certain requirements, there are only 85,000 of those visas available, and they are essentially made available through a lottery that takes place every April. And so it's not as simple as finding an employer who wants to hire you. Now, if you're going to go to an employer that meets one of the CAP exempt standards, then that's certainly a possibility. But so there's certainly an issue of timing of the H-1B visa and availability. The issue that always is of great concern to me is that many nurses don't understand that they are forbidden by law to pay any of the costs related to processing the visa. And there are certain employers that are kind of ethically questionable who will ask the nurse to pay for those costs. And if somebody approaches you with an opportunity like that, you should absolutely not participate in it, because it's fraud and it's going to create a significant problem for you and that employer down the road that you don't want to deal with. So the H-1B visa is a fantastic visa because what it lets you do is be in the US working while your green card case application is being processed. And that's fantastic, but it's kind of limited in terms of its availability, and it's limited in terms of when it can be filed. And so those are things that you kind of need to keep in mind when you're pursuing that with an employer.
How about H-1Bs, Dwight, for nonprofit employers? I know they get a slightly different treatment.
So they are eligible, nonprofit employers that meet certain standards, such as they're affiliated with an institution of higher education and they're actually involved in that institution and in taking activities that service the needs of that institution. So for example, if you have a hospital that's affiliated with a university and they have a program where the university sends students to do internships or some kind of curricular training or educational activities at the hospital, then they would certainly meet that requirement. And that hospital or a healthcare staffing company that is going to be placing nurses at that hospital, they have the ability to file the visas year round. And so that is a fantastic opportunity. But the issue is there are fairly limited rules as to which hospitals or which employers are actually able to do that.
Okay, very good. So, when we're speaking with applicants, that are saying, "Hey, I heard about the H-1B. Can I get in on the H-1B?" I think Dwight just laid out very well what some of the opportunities and obstacles could be, right? Many U.S. employers are not able to meet the threshold or make the standard that shows that their nursing positions in fact require a bachelor's degree. So that's a limiting factor. Right. And I think it's also true, while H-1B petitions, particularly for not-for-profit employers, are being approved, they're certainly not being approved at 100%, right? Where we would dare say for EB-3s to this time, right? Again, properly filed, bona fide employer, you would have a 99 point something percent chance of success. So as you contemplate H-1Bs, and we're certainly happy to provide you with more information on that, just bear in mind that there is some uncertainty, as USCIS has complete discretion over how these cases are adjudicated. So denials are a possibility, right? And that brings me to my next point, which was renewals depend on shifting rules year to year. So I think that's a great segue, Dwight, into the news here that broke late on Friday evening US time and has been a hot topic of discussion over the last 48 or 60 hours or so. So can you just give a high level overview of kind of what we believe has been announced and what the potential implications could be specifically for healthcare candidates?
So the first thing that I would say is that on Friday, the president announced that they were implementing a $100,000 filing fee for every new H-1B visa petition that was filed with USCIS after midnight on Sunday. And as kind of we have seen happen on a fairly regular basis, this announcement comes with very little detail in terms of actually how it's going to be implemented and who it's going to apply to. And if you just Google this issue, you will find numerous people offering numerous different opinions as to what exactly is going to happen. We know it doesn't apparently apply to people who already have been issued H-1B visas and are in the US working, so it wouldn't apply to their extensions, but to any new cases that are going to be filed, that apparently is, for the moment, the new standard. Now, I would certainly think that that's going to be immediately challenged with court cases, and it will be interesting to see whether an injunction is issued that says to the government, you can't implement this until it's more fully vetted. Normally, when the government is going to implement a new fee with regard to an H-1B, they have to go through an administrative process where they publish a notice in the Federal Register, and then they have a certain period of time where they have to accept comments, like 60 days before they're able to actually implement the new fee. So the fact that they announced it on Friday and said it's going to go into effect on Sunday night at midnight is very interesting. It'll be interesting to see how that actually gets implemented. The other thing is that the government has issued, a couple different people in the government have issued some clarifying statements, and unfortunately those conflict So we cannot entirely rely on those as being actually what is going to be how this issue is handled going forward. And then the other issue is that they also indicated that certain industries might be exempt from this if they happen to be an industry that has a significant value to the US. One would certainly think that that would be healthcare, but we don't know if that means it's only going to be cap exempt companies that can file cases without the $100,000 fee, or whether staffing companies that are supplying healthcare workers are going to be exempt from that fee. We just have no idea how exactly that's going to be implemented. So all I can say at this point in time is we know the president made an announcement on Friday. He said every new case is going to require a $100,000 fee, and it goes in effect on Sunday. And beyond that, what we basically have is a big bucket of confusion as to what, when, where, how, and why that's going to be implemented.
Yeah. Thanks for sharing that, Dwight. And just for sake of clarity, for those who may be watching a recording of this presentation at a future date, today is September the 22nd, and this presentation is live at about 9 a.m. Eastern time in the morning. So as Dwight referenced, information is forthcoming. Information has changed even over the course of the past 2 days after the announcement on Friday. We here at Worldwide Health Staff are currently working on a number of communications that will be shared today with our existing H-1B visa holding candidates, as well as those in process, as well as employers that will be employing these individuals. So please be on the lookout for communication on that as we get through the course of the day today. And as always, both for ourselves, and we'll show this information at the end, great way to keep up on the very latest is via our social media channels, or Dwight and his firm, their social media channels. I think the last point I'll make here is just, in the rest of today and the coming days, be extremely careful in terms of where you're getting your information on this topic from. A public chat forum, regardless of how large it is, may or may not be the best place. So you want to be very careful about the sources from which you receive this information. And certainly you don't want to act on any information that you have without speaking to your attorney or someone else who may be guiding your process. These are very serious matters, and a misstep could result in, significantly adverse, unanticipated consequences that can be easily avoided if you're just being diligent and ensuring that you're working with a competent professional who is dealing with the facts and not dealing with rumors or some amateur interpretation of what the issue is. So I'll just share that caution.
Ron, can I add one more thing?
Of course.
The
Yes.
one thing that I can say with absolute certainty is that I would recommend to anyone who's currently on an H-1B visa in the US not leave the US in the immediate future, even though some people in the government have said, oh, no, this doesn't apply to people who currently have an H-1B and they're outside the US. That's just a risk you do not want to take. And it may turn out that that is the case, but and I understand you may have travel plans, but our advice to everyone is if you're in the US on an H-1B, do not leave until we have further clarity on this issue.
Right.
That I can say with certainty.
Yeah, great point. Thanks for sharing that, Dwight. So just one last slide before we get to our Q&A, if we could move there. Again, just wanting to leave you with the thought that you can be confident in the process. We're talking about the EB3 process here now, right? EB3 remains one of the most reliable visa paths to this time, right? The EB3 program has existed since the late 1990s, right? Processing times may shift. We should almost change this to say processing times will shift,
Yeah.
right? We just don't know whether they're going to shift forward or backwards, but processing times will shift, but the outcome remains steady. And with patience and preparation, perseverance, your U.S. career goals as a registered nurse are certainly attainable. So with that, I'm going to ask my colleague, Allie, to rejoin us. And Allie, have we received any questions through the chat during our presentation?
Yes, a lot about H-1B, which you guys already covered. But there was a question about if their priority date is current, can you delay your interview date due to family issues?
Take that one, please.
So the answer is yes, to a degree. And what I would really recommend you do is contact your sponsor and lay out for them what the issue is, what your expectation for how long you're going to need to delay the case is. But depending on where you are in the process, I'll just give you one example. So your case has been approved, your I-140 has been approved, and now you've waited and your priority date has become current, but you haven't paid your fee bill yet. So that's the fee that has to be paid to start the processing of your visa. You have a fairly significant period of time to delay before you pay the fee bill. So if you talk to your sponsor and they understood, your sponsoring employer, and they understood what the need for the delay was, they can work with you to decide when you're actually going to pay the fee bill, which then triggers the next step in the process. The same is true once you've paid the fee bill, then you have some time before you complete the DS-260 and submit the required documentation. You can't wait forever to do that, and they can work through with you the timelines for when those things, but you can build into the process some delay that, so to a degree, you regulate how quickly you get scheduled for the interview. The only caveat I would say is that the worst thing in the world to do would be to delay the processing of that and then suddenly have the visa bulletin go backwards and suddenly your date is no longer current, and then you've missed out on an opportunity to come to the US right away and you're going to have a wait. But again, those are all kind of risk factors that you're going to need to discuss with the employer, your US employer that sponsored you, to figure out how in the world you go about working through that. But it is possible, depending where you are, to delay it some.
Okay. And if you're, or how long does the USCIS take to approve civil documents?
So, Ron, want me to run with that?
Yeah, sure.
So civil documents are actually, so the interesting thing about this process is if you're outside the US, there are really two major entities you're dealing with. The first is USCIS, who processes the I-140 immigrant visa petition. But once they're finished and that's been approved, if you're outside the US, they send your file to the Department of State. The Department of State is the government agency that's responsible for coordinating all activities at US consulates. And so once the Department of State receives it, your paperwork then goes to an agency, it's called, or a department called the MVC, and they are the department that actually processes the assembly of the documentation that's needed in order to prepare for you to go to your interview. So the MVC normally will, and this changes constantly, but I tell people normally think 30 to 60 days maybe, typically, for them to review your civil documents. Now, if there's something missing, there's a problem, you give them a document that's blurry and they can't read it and they need to see a clearer copy of it, or they have some other questions, or you haven't submitted everything, it can take them longer, and that's kind of dependent on the nature of the issue. But I normally tell people that generally from the time they receive those documents, think 30 to 60 days on average before you get the letter back from them. We call it the all clear letter that says, yes, your documents are all in order, everything's ready to go. The next thing we have to do now is wait for an interview slot to be available for you at the US consulate where you're going.
Right. And is it possible to take H-1B while waiting for EB-3?
Yes, there is absolutely no problem. The H-1B visa is a dual intent visa, which means that you can be coming to the US to work temporarily. It's a temporary work visa, so you can come to the US to work temporarily. But on the H-1B, you're also allowed to have the intent to remain permanently. So the fact that you have a green card case processing is not a problem. How you handle what you do with your green card interview when that finally becomes current, there's a couple of different options with that you'd really have to work out with your employer. But to the real question of can you do an H while you're waiting for your green card to be processed? Yes.
Okay.
Yeah. I would just add, Dwight, and correct me if if I haven't got this completely right. The answer to the question, as Dwight said, is yes, but it is also requiring that you and the employer meet the requirements of H-1B. It's not the fact that you have an EB-3 doesn't automatically convey the right or the ability to then file another H-1B.
Yeah, I would agree with that. Not every EB-3 case will be eligible to be approved for an H-1B visa petition. Yep.
Right.
Okay. And if their DS-260 was submitted in 2023 before the retrogression, will it need to be submitted again once priority date becomes current?
It doesn't have to be resubmitted, but the question then becomes, have there been any changes in your situation that would require changes to the DS-260? If there are monumental changes that need to have the DS-260 reopened so changes can be made, then you need to contact the employer that's sponsoring you so you can figure out how to address that. And one example of that is adding family members that weren't your family at the time that that I-140 was filed. Because when you file the I-140, you list all the family members that'll be coming with you, and then cases are created for them. Well, if you have a child, after that's all submitted, there's obviously no case created for that child. So you're going to have to work with your sponsor to get that process opened so that you can add the family member. So, yeah. But generally speaking, if everything's correct and nothing's changed, then you wouldn't have to resubmit it.
Okay.
Okay, Allie, one more question, and then I've got a question for Dwight, and then we're going to wrap up just in respect of the time.
Okay. Yeah, I just see a lot of questions about predictions for the visa bulletin for November. I know it's kind of a hard question to answer, but any thoughts on that?
I think we talked about right. We talked about that. I think if we look at the October bulletin and we look at the filing date, which indicates July 1st, right? I think based on that, we would expect to see very, very modest progress, if any, between now and the November bulletin. Dwight, do you see it differently?
No, I absolutely agree with that.
All right.
Yeah.
And then one question somebody sent to me here directly during the course of this presentation is from an individual who has indicated that their priority date is current, but they haven't been invited for an embassy interview. So, Dwight, can you just very quickly just comment on the relationship between a priority date becoming current and being scheduled for an embassy interview?
So the interesting thing is it's really impossible to predict how quickly you're going to have an interview after your priority date becomes current. But I think what's important to understand is that if your priority date has been fairly old and the MVC has maybe archived your file while it waits for that to become current, what we always get are questions of people that say, hey, my priority date became current. It's October 1st. Why don't I have my interview notice?
Right. I think that's the question.
Yeah, they have a lot of cases to process. They have to go pull them out, go through them, prioritize them in terms of the date, and then figure out what interview dates are available at the consulate. And sometimes that can take them several months to do. And so, I guess one thing we hadn't kind of really mentioned was that for employment-based cases, we saw kind of a real benefit during COVID, which was that many family cases weren't being processed. And so priority dates moved forward and we got the real benefit of it. And we now in the last 18 months have really kind of seen the family cases come roaring back. And that has affected the processing of employment-based cases, and it has affected how readily interviews are available. So we are now kind of back to a point in time where they are trying to squeeze the employment-based cases in to everything else they're doing. And you should not be at all surprised if you don't see it take 1, 2, 3, or 4 months from the date your priority date becomes current before you finally get your interview.
Okay. Thanks for that, Dwight. And Allie, thanks for moderating our Q&A session. I hope that you have found this information to be helpful. Many of the topics that we addressed today are not static issues. These are dynamic issues. So the information shared is obviously based on existing policy, existing regulations, existing practice. Immigration is a quickly evolving area of the law these days. And Dwight and his firm and us here at Worldwide Health Staff, we're determined and committed to keeping not only on top of these issues, but to communicating out to each of you the very latest accurate information that may become available from time to time. A reminder again that a recording of this presentation will be available within the next 24 hours on our YouTube channel at Worldwide Health Staff Solutions. If you believe a friend or colleague of yours would benefit from or be interested in the discussion that we've had today, please feel free to share the link to the YouTube recording or forward that to them. That would be greatly appreciated. And if you'd like to get in touch with Dwight, just drop us a note and we'll send you his contact information as well. Again, thank you for joining us today. Please continue to monitor our various social media channels for upcoming webinar topics. We try to have a wide variety of topics and subjects that we cover. We try to do a presentation weekly. So please stay tuned for that. And we look forward to seeing you all again soon.